The most elegant firing is the one the company never has to record as a firing. No termination meeting, no direct confrontation, no sentence beginning with, "We've decided to let you go." Instead, the job starts changing in pieces too small to look like the event. A pay structure gets revised, a responsibility disappears, a grievance stalls, a reporting line changes, access breaks and stays broken. None of these things, on their own, look large enough to justify panic. That is what makes them useful. The company is not trying to remove you in one clean motion. It is trying to alter the conditions of your employment until your resignation becomes the most administratively convenient thing in the room. By the time most people realize what is happening, the organization already has what it wanted, an exit it did not have to openly author. You leave, they call it your decision. The record shows a voluntary departure, and once it's written that way, correcting it becomes your burden, not theirs. The pressure that produced it is now scattered across emails, policy changes, meeting exclusions, delayed responses, and procedural shrugs, each one small enough to defend, all of them together large enough to end a job. Constructive dismissal is the legal recognition of a specific fact about how employment actually ends. A company does not have to terminate you for the termination to be real. It can change the job under you until the role you agreed to no longer exists, then treat your resignation as a voluntary departure. You leave, the company calls it a personal decision. The record shows you quit. The law, in most jurisdictions that recognize the concept, treats this as dismissal, regardless of who physically walks out the door. Two categories matter. The first is a single fundamental breach of the employment contract, such as a unilateral pay cut, a demotion without consent, or a forced relocation outside the agreed terms. The second is a pattern of smaller actions that, taken individually, each look defensible, but taken together, destroy the basic relationship of trust and confidence that employment depends on. The second category is where almost all real cases live, and it is where most employees lose. It is also where companies choose to operate, because it lets them distribute one act of removal across many acts of management. The reason that works is plausible deniability. Every action in the pattern has a business justification already drafted. A pay adjustment gets explained as a compensation review, a schedule change as operational need, a lost responsibility as part of a restructure. In isolation, each one is defensible. The company relies on you experiencing them separately, one at a time, and never arranging them in a line. Once they are arranged in a line, a different picture appears, and that picture is what the law actually examines. Pay manipulation almost never arrives as an announced cut. It can appear as a missed increase while peers receive one, or as a removed bonus structure replaced with vaguer performance criteria, or as a commission formula that now requires a target no one can actually hit. The benefit side has its own versions. A wellness allowance disappears. A stock vesting schedule gets revised. A car or phone allowance is discontinued with a short memo about aligning with policy. Your base salary may not change by a cent, but the expected earnings you signed on for have been engineered downward. A formal pay reduction would trigger questions and possibly a lawyer. A reinterpretation of the variable portion does not. What the company has achieved is a material change to the financial terms of your employment with no formal event it will ever have to defend. There is nothing to challenge because nothing was officially taken. Hours manipulation operates on the same principle from the opposite direction. You are either given too much in the form of sudden overtime expectations with no additional compensation and a workload expanded past what the original role described, or too little in the form of reduced scheduled hours for hourly staff or removed projects for salaried staff whose time is now visibly underused. Either version produces the same result. It forces a financial or scheduling decision that the company never has to make for you. You either burn out and resign, or you cannot sustain the household and resign. And in both cases, the paperwork records your choice. Relocation pressure is the cleanest version of this mechanism because it is often written into a clause you signed years ago without expecting it to be activated. A role that has always been local gets redefined as regional. A hybrid arrangement is withdrawn after being presented for years as permanent. A return to office mandate appears with a distance and frequency your life cannot absorb, announced on short notice with appeals handled case by case in a process that never quite resolves. The company is not firing anyone. It is adjusting the geography of the job until a specific set of employees, often those with caregiving responsibilities or long commutes, cannot follow it, and their resignations are recorded as personal lifestyle decisions. Role erosion is slower and harder to date. Responsibilities you used to own are reassigned in small pieces, usually framed as temporary coverage that never ends. A direct report gets moved under someone else for a project that keeps extending. You are removed from a client list without being told, and notice only when someone else is copied on an update about an account you used to lead. The title on your business card stays the same, while the work behind it is dismantled. When you finally ask what is happening, you are told you are being freed up for higher level focus, and no one can describe what that focus is. The company's advantage throughout this process is that nothing official has been removed. The title is intact. The salary is unchanged. The departure, when it comes, is yours to explain. The title stays. The job disappears. Impossible performance standards follow the role erosion or arrive alongside it. A new metric appears that no one on the team can hit, and it is applied only to you. A performance improvement plan is issued with deliverables that require access or authority you have already been stripped of. Deadlines compress. Every deliverable goes through an extra layer of scrutiny that does not exist for anyone else. The goals are technically documented, which protects the company, and technically unachievable, which guarantees the outcome. The failure, once produced, will appear in your file as a performance issue rather than a structural one. The outcome is decided. The metrics are just how it gets documented. Normalized hostility is the sign most people minimize the longest. A manager speaks to you in a tone they do not use with anyone else. Comments in meetings land as corrections where others receive suggestions. You are interrupted more often than other people in the same meetings. Credit for work you contributed to gets distributed away from you. Reviews come back harder than those given to peers at the same level. None of it is extreme enough on any single day to escalate through a formal channel. The consistency is the point. The environment becomes something you have to manage around, and managing around it is exhausting in a way that eventually affects performance, concentration, and health, each of which then gets cited against you. You are not being corrected. You are being repositioned. Retaliation after speaking up is the sign that tells you the earlier signs were not accidents. You raised a concern, asked for clarification, filed a report, or pushed back on a specific instruction, and within weeks, your workload, schedule, or standing changed. A project is reassigned. A scheduled development opportunity disappears. A previously friendly manager becomes distant. The timing is always explainable with a business reason the company has already prepared. What changed is that you now understand the cost of using any formal channel inside the organization, and you start hesitating to use them, which is exactly what the response was designed to produce. Ignored or fake grievance processes are the next layer. You submit something in writing. You are told it is being reviewed. The review takes longer than any policy document suggests it should, and the updates you receive are generic. The investigator, if there is one, is internal, reports to someone aligned with the person you complained about, and interviews you once. The outcome, when it arrives, restates the company's position, closes the matter, and creates a paper record that can be referenced later as proof that a fair process occurred and concluded in the employer's favor. The process was built to generate documentation of its own existence rather than to find fault. Isolation from information and decisions is often the most disorienting sign because it is the hardest to prove. Your name disappears from distribution lists. Meetings that affect your work are scheduled without you. Decisions about your department are announced to you at the same moment they are announced to everyone else, even though your role used to involve shaping them. Calendar invites stop arriving for recurring sessions you used to run. Channels you helped create get migrated without you being added to the new version. The position is still technically yours. The work has moved elsewhere, and the gap between the two is where the case against you is being built. Safety and legal risks being pushed onto you is a category employees consistently underestimate because it looks at first like trust. You are asked to sign off on something you are not qualified to sign off on. You are instructed to cut corners that, if discovered, will land on your file and not on the instruction giver. You are named as the responsible contact on a process with regulatory, financial, or safety exposure you did not build and cannot fully control. The surface description is delegation, empowerment, a vote of confidence. The underlying function is the transfer of liability onto an employee the company has already decided should not be in the role, which guarantees that any subsequent consequence lands somewhere other than the people who authorized it. Restructuring is the word used to cover several of the above at once. A reorganization is announced, roles are redefined, reporting lines are redrawn. Inside that redrawing, specific individuals find their position materially worse, scope reduced, reporting line lowered, team dissolved, while the organization as a whole is presented as having been optimized. Restructure is legally powerful because it converts targeted action into general policy. The position taken by the company is that the reorganization, rather than any decision about you specifically, produced the new arrangement. The fact that the new structure affects you in a way no one else on the chart experiences in the same combination is never the topic of conversation. The 12th sign is the one that ties the other 11 together. Any single adjustment can be absorbed, justified, or ignored. The accumulation is what produces the realization that the job you agree to is no longer the job you hold, and that the distance between the two was not built by accident. Death by 1,000 adjustments is an accurate description of the mechanism. Each cut is presented on its own justification, with its own memo or meeting or email available if asked about, and the employee is expected to absorb them one at a time without ever holding up the accumulated picture. That picture, held up, is a job you would never have accepted if it had been offered in this form on day one. And that is the fact the company intends never to have to acknowledge. Most constructive dismissal claims fail for a single reason. The events took place, but they were never recorded in a form that survives outside the employee who experienced them. A timeline built in real time becomes something a lawyer, a tribunal, or an investigator can examine. A recollection, however accurate, becomes testimony, and testimony is the weakest form of evidence available against an organization with written records of its own. Documentation begins before you think you need it. The moment something feels off is the moment to open a file, label it with a date, and begin recording what belongs in it. The signed contract goes in, along with the original offer letter and every variation issued since. Job descriptions, both as they appeared when you were hired and as they read now. Pay slips across the relevant period. Performance reviews. The written terms of any bonus or commission scheme, including the versions that have been replaced. For ongoing events, record the date, the time, the people present, and the specific words used where possible. Save emails, messages, and meeting invitations. Screenshots have a place, though exported records are stronger. When a conversation happens verbally, follow it with an email that summarizes what was said. A sentence beginning with, "Just to confirm what we discussed this morning," creates a written record that either gets corrected by the other party or stands unchallenged, and both outcomes help you. Pattern matters more than any single incident. A tone change in one meeting is anecdotal. A tone change across 16 meetings over 11 weeks, documented at the time, is a pattern. A missed inclusion once is oversight. 8 missed inclusions in a row, each logged by date, is an exclusion. The power of documentation is what it forces the company to explain about a sequence, not what it proves about any one moment within the sequence. Without records, the same events become something else in the employer's hands. A stripped responsibility becomes a natural evolution of the role. A demotion becomes development. A hostile review becomes coaching. A sudden schedule change becomes a misunderstanding about availability. Every undocumented event is a sentence the company gets to rewrite in its own voice. Every documented event is a sentence you hold. Documentation doesn't stop what's happening. It stops them from rewriting it later. If it only exists in your memory, it becomes opinion. If it exists in a timeline, it becomes evidence. The work of documenting feels unnecessary until the day it is the only thing that is not. Not every difficult workplace qualifies as constructive dismissal. A bad manager, a difficult quarter, a harsh review, or a prolonged period of friction do not automatically create a legal case. The standard in most jurisdictions requires either a fundamental breach of the employment contract or a course of conduct that makes continued employment unreasonable. And unreasonable has a specific legal meaning narrower than the everyday one. Context matters. Your contract, the written policies of the organization, and the industry norms that apply where you work. The difference between a legitimate operational change and a targeted dismantling of a role is sometimes a question of detail that only a qualified employment lawyer or local labor advisor can assess against the applicable law. Timing is its own risk. Waiting too long after a serious breach can be treated as acceptance of the new terms, which weakens or eliminates the claim. Resigning too early, before the pattern is documented or the final breach has occurred, can be treated as a voluntary departure the company never caused. Both errors are common, and both are usually made under emotional pressure the situation is specifically designed to produce. The correct response is to build the record first, get specific advice before acting, and treat any decision to resign as a deliberate legal step rather than a reaction to the most recent incident. Constructive dismissal is the mechanism a company uses when it has decided you should no longer be there but does not want the record to show that decision. Rather than issuing a termination, it reshapes the job until the role is no longer the one you accepted, and then waits for you to respond to a role you were never hired for. By the time they admit what happened, they usually do not need to. The record already says you left. The only question is whether your record says why.